Day 1, hearing in appeal of Tesco Income Iron, and another against Interdigital Patent Holdings and others.
Yes, Mr. Alexander. Before we get going, can I just check that we are all going to be using the same electronic bundle as we go through? I was assuming that we would use the redacted version unless anyone particularly wants to go into the unredacted version. Does that suit everyone?
I think that's right.
It will be difficult for us to skip between them with the same references, so I'd like to work from the same bundle.
Yes, I think there may be a need to, on the part of some, to refer to some confidential material.
Yes, of course. I'm not suggesting that one wouldn't, but that the default, if you like, will be the redacted, and yes, we'll go into the unredacted only for particular reasons, yes, if that's acceptable to everyone. Thank you.
Well, my lords, I appear with Mr. Likadopoulos and Ms. Azebciu for the appellants, Mr. Raphael, Ms. Ryan and Mr. P, for Interdigital, Mr. Nichols and Ms. Pickard, and Ms. Berkari for Avanci. This case, as my lords know, is in some sense a follow-on from Unwired Planet in 2020, which requires the court to consider how that jurisprudence should be developed. My Lord Sales predicted in an extrajudicial article about the work of this court in 2030 that this court might be considering issues in this domain, and we've come a little bit early to this subject. But part of the reason for that is this is a very fast-moving field, and our overall submission is that the jurisprudence of this court should keep up with that field developments in it and the approaches taken to licensing in this area since Unwired Planet. It's not surprising that this has become a significant part of the work of the intellectual property courts, although these cases are not of the traditional kind, where there's an attempt to prevent someone from undertaking particular acts on the market. These are cases that have just as great an importance, because what they do is essentially facilitate the exploitation on fair and commercial terms of important technologies and facilitate the collective production of those technologies, which are in many ways fundamental to many aspects of modern life. So what I propose to do is to undertake an overview, cover the issues on grounds 1 and 2.
So sorry, could you get any time to come with a problem? Yeah, please continue.
1 and 2 of our appeal, which will also deal with Interdigital's cross-appeal on the declarations issue. Those topics will deal largely with the question of whether the English courts should be making determinations of this kind, and if so, how that should be done procedurally fairly and in this country, bearing in mind the various interests involved. And I'll lay the foundation of some of the jurisdictional points on gateways and forum non-conveniens, which Mr. Likadopoulos will then deal with primarily, if that's acceptable to my lords. While this case undoubtedly has global implications and aspects, one must not lose sight of the fact that it is, in fact, at heart a UK patent case seeking determination of what a FRAN terms under a license for those patents, what it would be FRAN to pay under a license for those patents, which would otherwise give rise to a potential claim for infringement. So I propose to structure the submissions in the following way. After an overview and some background, which will be relevant to the approach that the court should take to the ETSI undertakings and how they ought to be applied in this context, I'll deal with serious issue to be tried, and then approach to declarations, the useful and legitimate purpose that they serve, and conclude this part by some observations on how the court can ensure that relevant interests are taken account of, and that the approach that we commend is in accordance with recent thinking, in particular from the Tyne and Weir case. So turning to the overview, our argument has the following key elements. First of all, IDPH is the proprietor of the standard essential patents in issue in this case, which have each, not on a patent-by-patent basis, but for each patent, being declared to be essential to the relevant standards, and are also each subject to the declaration that licenses on FRAND terms will be available in relation to them. That declaration affects each of the patents, although obviously it's an undertaking that's given by the proprietor of the patents or on the proprietor's behalf, in this case, the now second respondent.
There are three of them, Mr. Alexander, is that right? There are three patents.
There are three patents in the UK.
Held by IDPH.
That's right, in these proceedings. I don't know whether there may be other patents, but those are the ones in issue in these proceedings. And the relevant declaration, ETSI declaration, was given by IDH on behalf of IDPH, in that it was given on IDH's behalf and on behalf of all other companies, essentially, in the Interdigital group. Now, prima facie, of course, those patents give Interdigital the right, if valid, to prevent the sale of products in the UK if doing so would infringe, and they're in fact essential. My clients, in my submission reasonably, seek to know what they need to do, in effect, to avoid infringement of those patents. Each of them is subject to the ETSI undertaking, but the ETSI...
Just allow me 1 minute. I'm so sorry to interrupt.
Each is subject to the ETSI undertaking, but the undertaking, and we'll come on to that in greater detail, doesn't specify the nature or characteristics of FRAND licenses or what is required for a license to be FRAND. The undertaking only says that FRAND licenses must be available in relation to the patent in question. In Unwired Planet, this court and the courts below held that in order to be FRAND, essentially what was required was that there should be a bundle license of all of the patents in whatever jurisdiction on a global basis. And that was the correct approach to identifying what the FRAND license was in that context. That was a situation in which obviously no issue of a platform license arose, but the patents in question, there was a debate as to whether there should be country-by-country licensing, but there was no debate ultimately that the license that ought to be granted was a global license involving the bundle of all of that proprietor's patents that were potentially said to be relevant.
Yeah, so, I mean, it was a significant feature that, as you say, it was a bundle of all that proprietor's licenses.
Indeed.
That proprietor.
Either a single proprietor or group.
Yeah. Or group, yes, indeed. And it will be our submission that the approach that should be taken to what might be called inter-group bundles should not be different from the approach that's taken to intra-group bundles as regards the applicability of the undertaking and the requirement that the license should be on FRAND terms. The basis for that determination was essentially an examination of what was regarded as appropriate in the marketplace. And there was evidence that licenses were generally global licenses, and that there was also evidence that it was, in the words oft-repeated, madness for there to be country-by-country licensing. It would create enormous inconvenience and would also potentially be unfair to patent proprietors who would then have to go and essentially chase down infringers in multiple countries of the world. And as my lords may recall, that case was decided against a background of the issues of hold up and hold out, probably being thought to be more on the side of hold out, and I'll come on to that. And that there was a concern that if you did country by country licensing, you would give a charter to implementers to not pay their dues for essentially substantial procedural reasons. And I'll come on to that in a moment. But that was the background of Unwired Plan Act, which looked to the market. Subsequent cases have developed that and held that in appropriate circumstances a FRAND license would be a cross-license to the bundles of patents of more than one proprietor. So our submission is that essentially IDH and IDPH, who are the ultimate licensors, who use Avanci as an agent, both as their agent and as their intermediate licensee, offer two kinds of bundles of patents, all of which are subject to the ETSI undertaking. One of them is what they describe as the bilateral license, which we would submit as a bilateral bundle, and there's no question that that bundle has to be provided on FRAND terms. But they also, through the agency of the Avanci pool, offer this multilateral or intercompany bundle, which licenses all of the patents bundled together with the patents of others. Again, all of which are subject to the same ETSI undertaking. And our submission is that it's not sustainable, or at least for present purposes, it is, there is a serious issue to be tried as to whether, if bundles are offered in one way, namely by all of the group companies, and are subject to the obligation to provide them on FRAND terms, that obligation simply goes away in respect of the other form of bundled licensing, which licenses all of these together. And we respectfully submit that it is arguable, at least, that that doesn't go away, that there is nothing in the ETSI, the language of the ETSI policy, which suggests that it does, and that there are very good policy reasons, bearing in mind the objects of the ETSI policy, one of which is to prevent holdout, as to why the policy should not be regarded as discharged simply on the basis that Bundle A, which is subject to FRAND terms, has been offered, and then there's a free-for-all in relation to all other kinds of potential bundles.
Right, it's not, as I said, it's not put against you that it's a free-for-all, it's put against you that this is a commercial alternative, which doesn't purport to be an ETSI-bound FRAND offer.
Yes. Yes.
Rightly or wrongly, that's as I understand it, the case put against you. It's a commercial alternative offered by Avanci, which in its own way may help to keep bilateral licensing under control.
Yes, that is the case. And when I say free-for-all, what I was intending to advert to was a form of licensing that was simply not affected by the ETSI undertaking in any way. It was not one where any of the patents, even though each of them was subject to the ETSI undertaking, was in fact subject to the undertaking. Because the consequence of Avanci's respondents' position is that there is no limitation on how those patents can be licensed. They say that as a matter of their practice, they claim that they are FRAND. Obviously, that's a matter that's disputed. And it's also said that because of the ETSI undertaking in relation to the what's called the bilateral license, that has an impact. But in principle, there is no constraint. And I'll show my Lord some reasons why we say that's not an approach that should commend itself to this court in the context of the current market and how it's developed. And until the case reached this court, it was, as we understand it, accepted that it was at least arguable that the Avanci platform license had to be FRAND. And it was accepted by, it was said by both Avanci, by Avanci, Interdigital not taking a position in relation to this, that in fact it was FRAND and was designed to be. And in our respectful submission, that is quite a powerful point in favour of suggesting that it is in fact arguable that this form of licensing both should be FRAND and that there is a reasonable case that may be developed that this is the FRAND way of undertaking licensing in this area. So we respectfully submit that the claim is arguable on two related bases. First, that the commitment doesn't cease to apply if there is this form of joint licensing, and secondly, that having voluntarily placed its license into this pool as a matter of commercial reality, the license of UKSC put into the pool is a global platform license. And there is a third aspect to our case, which we do advance as well, which is that we submit that there is a serious issue to be tried as to whether, even assuming that the respondents are right, that there is no obligation for the Avanci license to be FRAND, that there is nonetheless a useful purpose in determining whether it is in fact FRAND. As Mr. Justice Fancourt said in first instance, it is obviously of interest to implementers like Tesla to know whether the non-negotiable terms that are offered by Avanci are FRAND. Commercial rationale for Tesla's licensing claim is clear. And we would say that there is an obvious interest on both sides of what this might be described as a two-sided platform in knowing that. There is an obvious interest in licensees knowing whether they are paying the right sum, and there is an obvious interest in licensors knowing that if they offer a license through the Avanci pool, that license will discharge their obligations, because they'll then be able to say, well, you must take the pool license in relation to these patents, because that bundle license discharges our EXI obligations with respect to that collection of patents. And the advantage for the industry in that is enormous, because what you then have is the avoidance of needing to go to, in this case I think now 85 separate licensors to negotiate individual licenses with them, and to have on the other side a very large number of licensees engaging in individual disputes. All would know that they were getting a license that was to all of the relevant rights, or in this case a substantial number of the relevant rights, and that was discharging the ETSI obligations and was on FRAND terms. That, in our respectful submission, is in some sense the ideal in the context of a platform of this kind, because it avoids a whole lot of problems for the industry. And we respectfully submit that English law relating to what might be called the procedural assistance that it gives to advanced technology industries should be slow to say that that is something that it cannot do for whatever reason. There is a further argument that has been made, which is a new argument by Avanci, where they say, and again for the first time I think in the entire proceedings, I haven't been able to detect any earlier point in their written case on the 23rd of March, where they say that there was an express exclusion of the FRAND obligation from pool or platform licenses as a result of travaux préparatoires that they have referred to. There was nothing of the sort, as we'll see, and I'll try and deal with that point fairly briefly. But there's nothing to suggest that the ETSI scheme would have said that pool licenses or platform licenses should be excluded from from the obligation. So in our respectful submission, there are compelling what might be called public policy reasons, although in this case they apply to an industry, for adopting the approach taken by the minority in the Court of Appeal, Lord Justice Arnold. Some of those points are highlighted, as I shall come on to, by the interveners in the appeal, and partly the reason for that is that it's increasingly common for SEP licensing to take place by way of these platforms, and it is important that there are available mechanisms of determining whether that there are mechanisms of determining whether these licenses are FRAND and fulfil the obligations.
Sure, so in front of the judge, it appears to have been largely accepted that it was arguable.
Yes.
Did the difference become apparent in the Court of Appeal?
I wasn't at the Court of Appeal, but so far as I understand it, that became the case in the Court of Appeal. As far as I detect in the course of the argument in the Court of Appeal, while before the Court of Appeal, again, it was not disputed that it was arguable, during the hearing, and I'll be corrected on this if I'm wrong, essentially, if I can put it colloquially, the respondents ran with some observations from the bench, which then formed the central part of the reasoning of the majority in the Court of Appeal. But
can I just ask, do we have the Court of Appeal skeleton arguments?
It's referred to in your case.
They are referred to. I don't think that they are in the main hearing bundles, but they can certainly be made available to you.
Yes, please.
Perhaps I can come back to that. Yep. The final element of this aspect of the case is the procedural one, or perhaps it's the crossover of declaratory relief and procedure. There are actually two aspects to that. One is whether or not, in principle, if my lords accept the basic argument that it is arguable, a declaration can be made, given the various parties to this case. And that is a point that arises as to whether or not the declaration can be made between my clients and Avanci, even though there isn't an ETSI obligation that binds Avanci. And then there's the series of procedural objections.
So just on that, I mean, it would be a declaration, would it not also in relation to your clients and Interdigital?
Oh, yes, yes.
And and Interdigital do owe the ETSI?
Yes, absolutely. But the reason I mention it to my lords is that it might be said that there is an underlying set of issues in this case, or at least that aspect of the case, namely the powers of the court to make declarations in respect of matters where there isn't a direct contractual relationship between the person claiming the declaration and the respondent. We say that the law is sufficiently clear on in that area, albeit that it has not been specifically articulated, I believe, by this court, but it has been on a number of other occasions, that it is possible to do that, notwithstanding the fact that there isn't a contract.
This court hasn't looked at declarations, has it, since it looked at injunctions in the Gypsies case, following on from the Privy Council in Convoy Collateral?
That is probably right,
because, I mean, they're both equitable remedies. It may be that there's some learning to be had from the Gypsies case, and indeed Convoy Collateral, where Siskina was first.
Yes. Well, I'm bound to say, in preparing this case, it did occur to me that on this aspect, there may be a substratum of power jurisprudence, if I may put it like that, relating to the approach to declarations that had not been quite as fully briefed, if I may put it like that, as your lordships may wish to have if and insofar as you wish to make wider observations in relation to declarations. We do not say that you need to do that in this case, because our case on this is actually much simpler. In a case which concerns the nature of an obligation as between a claimant and a respondent, which is subject to the obligation, it is appropriate to make a declaration in any event, and that's the IDH case. It is made even more appropriate if the nature of the obligation and the real issue is between the contracting party's agent, in this case Avanci, and that in this case all proper parties to make a declaration are before the court. So can I then turn to a few points of background? My lords will be very familiar with Unwired Planet and the points made there in relation to the purpose of the ETSI scheme. One of them, the reason we have declarations of an entitlement to license on plan terms is to deal with hold-up. And that's dealt with, we don't need to go to it, but in Unwired Planet in this court in paragraphs 11 and 12. And it's been referred to in a number of cases. As I've said, hold-out, which is one of the other issues that this area seeks to address, where implementers use tactics to avoid paying FRAND rates, was some of the background to Unwired Planet. But hold-up is the real purpose, or avoidance of a hold-up, is the real purpose for which the ETSI declaration is there. Because what you don't want to have is a situation where someone gets their patent into the standard and then either is unwilling to grant licenses on FRAND terms or seeks to obtain payment in respect of those rights that exceeds fair, reasonable and non-discriminatory compensation, because that is unfair to all others who are seeking to implement the standards. Obviously, it's in the interest of standards essential patent holders to try and do that, because who would turn down the opportunity of getting more than FRAND? And we have seen in the years since Unwired Planet that being an increasing problem, and specifically in this area. And I will show, my lords, briefly, very briefly, why this is a big issue. The second point of importance is the significance of patent pools and platforms. Although they have existed for some time in this area, there is an increasing trend to make use of them, and this is for good reasons. It is no part of my case to say that there is anything wrong with platforms or pools. Quite the contrary.
You're using pools here in the generic sense of including platforms.
Yes.
I believe some people tend to use it as a sort of distinction from platforms.
Yes, and there is a distinction. It doesn't matter for this aspect of the policy argument, but it may for others. So a patent pool is ordinarily one in which, or may be regarded as one specific to a situation where people all agree to assign a patent to a particular entity, so that there's literally a right in the pool entity itself to then undertake the license. The platform license is much more like an agency arrangement. Well, we see it's an agency arrangement, whereby there is simply a funnel created through which licensing takes place of the patents, which remain in the proprietorship of the undertakings, but the administration, including setting the terms, collecting the money, and so forth, is all done by essentially the licensing agent in this case. We're dealing with a platform here, but the issues in relation to the utility of platforms are in this context really very similar to those of patent pools. Indeed, one might say that they're even greater in the context of an industry which is subject to standardization, where really what you want to do is try and minimize the transaction costs and have those pools. So the interveners have important matters to say on this. As the MPA who's intervened says, and I don't think we need to turn it up because my lords will have read it, but it's just to ensure you have it in mind. The use of patent pools has historically been the predominant model for the licensing of the majority of SEPs relevant to audio-video codecs, which are obviously very important for video transmission. The MPEG-LA pool comprises over 90% of all H.264 SEPs. We understand that Avanci at the moment is now seeking to expand its own programs for these bundle licenses to other areas than automotive. But that, in our submission, makes it more, not less important, that these platforms are subject to what might be called proper price regulation.
Would you say, as I understand, MPA argued that set pool licenses can become effectively the only way to secure relevant license?
Yes. And I'll show my lord why that is the case, or why there's material showing why, for practical purposes, that may be the case. Because
an example that sticks in the mind from looking at the interveners is the maker of a very small number every year, or let's say high-grade sports cars that want a 5G license, which might not have the same department within its litigation department dealing with IP matters as Tesla or a large manufacturer.
Indeed, my lord, I was going to come on to that, and my lords have got that in mind, but the App Association, which represents micro, small, medium-sized businesses, makes the point that there will be 50 billion connected devices, because we're not just dealing in this case with the principles that ought to apply in relation to automotive manufacturing. My lords may say, well, why do I concern myself with the Teslas and Mercedes of this world? They can look after themselves. It doesn't matter. I'll come on to why that actually isn't even the case in relation to them shortly. But this is a case that concerns many potential small undertakings who need licenses to do things to connect to the cellular system for all sorts of purposes. They're not in a strong position to negotiate individually. The idea of saying to a small licensee, right, you've got to negotiate with 85 different SEP owners, or your option is to take a license described as a convenience license, and we can't warrant that that's a license on FRAND terms, but that's your choice. You either have the FRAND license with the 85, or you go down this funnel. That intervention also refers to the United Kingdom Intellectual Property Office's SEP consultation, which was only available after the Court of Appeal had handed down its decision, which actually found that this was an issue that affected SMEs, or potentially affected SMEs in particular. They rely heavily on standardized technology such as 4G.
Sorry, can you just give us a reference?
Oh, I'm sorry, my lord. It's the App Association's intervention. It's in Key Documents, tab 8. And so it will be in the electronic file at page 189 onwards. And I do commend that to my lords. The key points are made in paragraph 7 to 9 in relation to that. And there are references to the UK IPO's consultation in paragraphs 20 onwards. And we respectfully submit that those are very important points that are made as to the significance of a collective license of this kind being FRAND and the position of those which the law ought to concern itself with. And as has been said by the FSA, the Fair Standards Alliance, whose submission is at the next tab from 204 in the bundle at paragraph 24, the presence of pools or platforms shouldn't become a vehicle for what they describe there as FRAND evasion, which would encourage SEP owners to form platforms to obtain them profits that are not regulated by FRAND, and say, well, you can see whether you can get a FRAND license from the other 85 or whoever, because it depends on which platform one's dealing with, from another route. So the answer, my Lord, is yes. We are concerned here not just with Tesla's, but also, and in fact, potentially, in particular, many other licensees for whom transaction costs are a real issue. But can I just show my Lords very briefly why this issue is of real concern even to the largest undertakings in the world? And if I can just invite my Lord's attention to Appendix 1 at tab 35, because there was some evidence.
What electronic page are we on?
My Lords, a picture.
Mr. Alexander, could you give us the electronic page? We're all working from electronic bundles.
530.
Thank you.
And this is the third witness statement of Ms. Hopewell, one of the solicitors for Tesla. And what she outlines, starting at paragraph 15 and on to paragraph 35, is the position that even some of the largest automotive companies in the world have faced with respect to these licenses. And I don't invite my Lords, obviously, to read this now, but I do respectfully invite you to give attention to this at some point in your deliberations. May I just show you one highlight from it in paragraph 21 at electronic bundle page 538. Ms. Hopewell is setting out in this section the numerous actions that have been taken by SEP owners to try to obtain injunctions against the largest companies to persuade them to take licenses. And it has indeed resulted in a number of those undertakings taking licenses, in this case on the 4G pool terms, which was the previous generation of the standards. In relation to Mercedes, Ford, Volkswagen, and others, there are campaigns brought by SEP owners in multiple jurisdictions, often seeking injunctive relief with a view to either forcing the license that is desired or forcing a license into the pool. So the highlight of this might be the one against Ford Motor Company that in paragraph 21, where IP Bridge, which is a patent-owning undertaking, was awarded an immediately enforceable injunction against Ford in Germany, which, if enforced, would have required Ford to recall infringing products from retailers, destroy infringing products, and by this is not this is motor vehicles, and halt the manufacture and sale of its infringing vehicles. Ford joined the Avanci 4G vehicle program soon after the German ruling. So the pressure that is put by SEP owners on very substantial companies affecting their entire markets for products of which the standards essential patent may not only not affect the whole of the product, but maybe only one patent out of thousands that may affect that product, is a very real concern. And so my learned friends say, well, what a success the pool has been. It is not surprising in the face of that kind of attack that the pool is successful in some sense. You would have to be a very robust undertaking to say, well, I'm not going to sign up to the pool terms, and I'm going to risk the whole of my German market for motor vehicles. That's the context in which this case arises.
Just to be sure, the Avanti 4G vehicle programme is the immediate 4G predecessor.
That's the predecessor. That's the predecessor. And my lords, I don't want to say that applies directly to the 5G point, but it is the kind of thing that is going on, and it's not surprising then that one finds that people say, well, all right, if that's what I'm facing, what real choice? What real choice do I have?
Mr. Alexander, one has to be a little bit wary of this, doesn't one? Because we don't know the background of this. We don't know whether or not Ford approached the licensors saying, may we have a bilateral license in relation to the worldwide portfolio of patents affecting 4G, 5G, or whatever. And if they aren't going to do that, it may be said, well, what are the patentees expected to do except bring proceedings in one or more jurisdictions? We don't know why they took the pool license as opposed to a bilateral license. I mean, I'm not disagreeing with you. I'm just saying one has to be a little bit wary, does one not, about the background to any particular case, particularly when one's dealing with an entity like Ford. One may assume they're pretty sophisticated and they've got a very good idea of precisely what they're going to be facing if they don't come to the licensors saying, may we please have a reasonable license.
My lord, of course I accept that point, and one would need to look at the background with some care. My point, though, was more limited than that, which is that because of the power that SEP gives to a proprietor of an SEP to obtain injunctions or raise the risk of an injunction if a given license isn't signed up to. That is an important context in a market in which there is a significant amount of licensing through a platform, as to why the platform terms that are proposed ought not to be immune from FRAND consideration.
Well, that's a broader point, but I think one must be just a little bit wary about drawing too much from those conclusions from a limited illustration when the background isn't entirely clear, at least from the paragraph you showed us.
Yes, you're right, and I would invite my lords to read the whole of that section, because on page 543, what noted by Ms. Hopewell is that IP Bridge, so the same undertaking that we were considering, it's paragraph 34C,
yes.
Relied on the Avanti 4G license offer as a FRAND offer at a hearing on the 19th of May. And so this is not just a situation where you have licensors saying, well, of course you can come and approach me for an alternative. This is a situation in which licensors, and this is a matter that was referred to by the Court of Appeal, do say this pool, or this platform license, is the FRAND license. That's why you should grant an injunction. It's because it's FRAND. So, although my lord is quite right to say one needs to look at the context, an important part of that context is that these are relied on as being FRAND terms. And against that background, to say, well, in that case, there ought to be a mechanism for determining whether the terms are in fact FRAND is not, in our respectful submission, an unreasonable proposition. The final point on background that I'd want to just draw attention to is the approach of the European Commission and the competition authorities, and I can take that, I think, most rapidly from the supplementary bundle at It's SDP 32. This is an extract from the guidelines on the application of Article 101 of the Treaty to technology transfer agreements. So it's guidance on the technology transfer exemption. And at 286, starting at SDP 31, the guidance given in relation to pools is set out with respect to the safe harbour provisions. And what's said there is that the creation and operation of the pool, including licensing out, generally falls outside Article 101, irrespective of the market position of the parties, if all of the following conditions are fulfilled. And there is a number of conditions there that are referred to. The important one for present purposes is condition F on page SDB 32, that the pool technologies are licensed out by the pool to all potential licensees on fair, reasonable and non-discriminatory terms, including provisions that ensure that licensees are not charged more than once for the same technology rights. And that is referred to in the notes on that guidance in the next tab, so SDP 38. This is a very recent update to the technology transfer guidelines issued on the 16th of April this year. But as my lords may know, there have been guidelines on the application of the technology transfer block exemption for many years. They just happen to be updated.
And presumably they've all said FRAND is important because that is the
exactly
competitive control within, if you're going to earn your exemption from Article 101.
My lord, that's exactly the point. The final point on this is in paragraph 17 on the note on SDP 38, where it's said under B, under licensing conditions, the revised guidelines state that pools must avoid double dipping and must ensure that licensees are not charged more than once for the same technology rights. In addition, the existing condition that the pooled rights must be licensed out on FRAND terms has been amended to clarify that this also applies to the licenses granted by the pool itself.
So where is that you've just been reading from?
Where?
Page 38.
I'm reading from
Page 38, middle of 17B.
it's paragraph 17, SDP 38,
okay.
17B, the last sentence of that subparagraph.
Got it.
The earlier version of this is in the bundles, but the point here is merely a clarification of the earlier version, and that has been part of European Community law guidance for a considerable period, my lord.
No, well, again, one must be just a little bit careful, one must not, because this is not a case which raises any competition issues. We're looking here at, as I understand your submission, the scope of the ETSI undertaking and the extent to which it imposes the FRAND obligation on the Avanci pool licence.
Yes, and I entirely accept that. But the point of all of these submissions is not to say that these are conclusive matters with respect to interpretation of the ETSI obligation. Not at all. My point is that insofar as the ETSI obligation is there to avoid holdout, which we say is a proper basis for interpreting the ETSI obligation, these points show why it is important to interpret the obligation as one directed to resulting in avoiding holdout, and the policy of the competition authorities supports that approach to the ETSI undertaking.
So you can't avoid it by licensing through a pool.
That's right.
Or a platform.
Or a platform. And in particular, that the pool and platform licenses have to be FRAND, we would submit, in order to give effect to the policy of avoiding holdout. That's my submission. So, for all of those reasons, we respectfully submit that it is therefore unsurprising that it was not contested until argument in the Court of Appeal, that it was arguable that the Avanci license had to be FRAND. There are many good reasons why that is the case, and many good reasons why the ETSI undertaking should be interpreted as requiring that. And we respectfully submit that there are really no good reasons on the other side. There is a strong public policy in encouraging platforms. There is equally a strong public policy in encouraging them to be on FRAND terms. And we've put in a number of points in our written case references to situations where there has been reliance by SEP owners on the fact that the pool, that the license is FRAND. What's said on the other side is, well, that's in relation to other pools, not the 5G pool, but in relation to the 4G pool. And essentially what Avanci is now saying is, well, we're not saying anything about the FRANdness of our pool or any obligations that it should be. And we respectfully submit that it is there is at least a serious issue to be tried as to whether that obligation exists. So can I turn then to the core reasons?
And sorry, when you say that obligation exists, I'm understanding you not to be saying it's an obligation on Avanci itself, but it's always an obligation on the SEP owners.
Yes,
but
that's right.
Do you go so far as to say that a SEP owner must make sure that every offer which it or its agent puts into the marketplace must be FRAND, or simply that in response to an implementer wanting a license, it must make a FRAND offer, even if it's made half a dozen others that aren't? I'm just trying to understand what you mean by the obligation.
We do. The reason I'm hesitating, my lord, is because there may not be a practical difference between.
Well, I'm afraid there's certainly a conceptual difference.
Oh, no, my lord, I entirely accept that. There's a juridical difference.
And I'm not sure saying it doesn't make any practical difference will avoid sleepless nights.
No, the reason I said is perhaps for a slightly different reason, which is that the obligation is to make licenses available on FRAND terms. And our primary submission is, yes, if the obligation binds that patent, essentially, or is referable to that patent, then offers of licenses to those who wish to implement that patent must be on FRAND terms.
May I ask you two other questions, Mr. Alexander? First of all, is a SEP owner obliged to make one offer of a license on FRAND terms, or any offer that it makes of a license of that patent? Does it have to be on FRAND terms?
We would say that the SEP owner is obliged to make all of its offers for licensing of the SEP, of the SEPs, on FRAND terms. Now, it may be the case that there may be other offers that a SEP owner may make, which, for example, fold in non-essential patents or other technology rights and so forth. But if and insofar as one's dealing with an offer for standards essential patents, then those offers ought, in our respectful submission, to be FRAND. We have a secondary case in relation to this, or the second aspect of our case, which is that as a matter of, as it were, fact in the market, it may be that in given circumstances, even if a SEP owner is not obliged to make every offer FRAND, it must do so with respect to given offers. And we say that that would apply to the Avanci pool in any event. It must make the Avanci pool offer or Avanci platform offer on FRAND terms, and the obligation to do that is affected by the platform terms
As I understand
being FRAND.
Thank you. I'm sorry, I didn't mean to cut you short.
No, please.
As I understand your written case, you go as far as to say that the only offer here which is capable of being FRAND is that through the Avanci platform. Is that right?
Yes, we don't need to go that far, but in our respectful submission, there is a serious issue as to whether that is the case in this context. And part of the reason we say that is because of this, because of the way in which the practice has developed of licensing through the platform. Now, my Lord may say in response to that, well, at what point does that obligation arise in, for example, the development of a pool?
Yeah.
And there may be questions that arise in relation to that, but they're questions of the same kind as arose in Unwired Planet when there was a debate as to whether or not the license should be a global license or a national license. Those are questions which would need to be determined, the facts at trial, and for present purposes, which is only jurisdictional, we respectfully submit that there is a sufficient basis for saying that the court might conclude that that was the right way and that those terms should be FRAND on that basis.
Well, certainly, as I understand it, the case put against you, no doubt you'll come to deal with the detail of it, is that Interdigital are prepared to offer bilateral licenses of their SEPs on FRAND terms, but you haven't yet gone to them and asked for one. That's their position. Yes. They say that meets their FRAND obligation. And as I understand it, your written case in answer to that is, well, in the circumstances of this case, only a platform license will be FRAND for reasons I think you've touched on. And so the fact there has been no approach made or undertaking to take a bilateral license on FRAND terms is neither here nor there.
Yes.
In the circumstances of these cases, where a platform license is available, the obligation is to provide that on FRAND terms, and that is all that will meet the ETSI undertaking.
That's right. That's the second part of our case. We have two aspects to this case, and those are reflected in paragraph 27 of our written case. At page 36 of the electronic bundle. And I'm coming on now to deal with those head on.
Yeah.
Just on the second, my Lord was putting to you that your argument on the second limb is that it's only a platform license that will be FRAND. I just wonder whether it's a slight variant of that inherent in the way you were saying before, that the ETSI obligation is to make available on FRAND terms, that it's only the offer of a license on the platform that actually is in practical terms available, because no one would go around the world seeking to negotiate bilaterally across the whole of the SEPs on the platform.
That's the crux of the matter, is that in circumstances, certainly where the majority of SEP owners, and in particular the important SEP owners, had chosen to put their SEPs through the platform, for practical purposes, in respect of those SEPs which have the obligation, the only realistic offer that is available in a commercial sense is the platform offer, because the alternative is the other 84 licenses. That's the second aspect of our serious issue, and we respectfully submit that the minority in the Court of Appeal, Lord Justice Arnold, was entitled to find that there was a serious issue on these facts as to whether that was the case. The first point it arises, in a sense, independently of that, namely whether if you have an obligation to grant licenses on FRAN terms, you strip yourself of that obligation by licensing through a platform.
Well, except that, I mean, isn't that rather a mischaracterization of the case on the other side? They don't say that they're stripped of the obligation. The obligation is always there. They just say they satisfy it in a different way.
My lord, that's right. But the reason that we put it like that is because if it is right, and perhaps this picks up on a point made by my Lord Briggs, if it's arguable that all offers to be made in relation to SEPs must be on FRAND terms, then that aspect of the argument in 27.1 would kick in, because what we submit is that if you license through the platform, you can't say, well, because licenses are available outside the platform as well, that means that the obligation doesn't affect licenses made through the platform. So there are two aspects to this.
We're going to have to look very closely at the ETSI undertaking to see whether it goes that far.
Yes.
Yeah. And do we have expert evidence of French law on its interpretation?
No, there isn't. But the reason that the ETSI undertaking doesn't go, the ETSI undertaking doesn't address this issue at all. We've got the ETSI undertaking on the previous page in the page before that, page 34 of our written case. And the ETSI undertaking is in entirely general terms. It does not specify exactly what terms are to be FRAND, how that should be evaluated, or even a choreography in relation to the making of those terms.
No, but just on the point that we're debating, I mean, I think Interdigital say, well, we are prepared to grant irrevocable licenses bilaterally. We are always going to comply with the ETSI obligation, and perfectly happy to do so, but just through the bilateral route.
Well, we respectfully submit that it is at least arguable that that obligation is not exhausted by simply saying we are prepared to grant a different form of license, which is subject to the ETSI obligation. The obligation extends to granting licenses under the SEPs, each of which has to be subject to the FRAND terms.
Can you...
I'm sorry.
No, you'll come to this as well, but when you say it applies to all the obligations in relation to whatever offers one makes of those SEPs, when one's dealing with it through the platform is, of course, formulating an offer of not just that SEP owner's patents, but also all the others, which are 75 plus licensors that have joined the platform. And it may be said, well, it's quite a tough obligation to impose on one SEP owner, an obligation to ensure that the Avanci license is FRAND, when that particular SEP owner has no control over the terms upon which the Avanci entity will formulate the terms for the other SEP owners on the platform.
Well, that depends on really how these terms are set, and I'll show my Lord briefly how that comes about. We respectfully submit that is an exaggeration of the complexities here, and perhaps it's convenient actually just to show my Lord this in relation to the 4G pools, so that there's an element of realism, because that will come on to form a platform for some of the issues on declarations as well.
Just before we move away from the ETSI undertaking itself, we don't have any expert evidence about how it would be interpreted in French law.
No.
Does that mean that we approach it as though English principles of construction apply in relation to it?
We do have some evidence about the principles of construction under French law, don't we?
There is
just not applied to this undertaking.
There are observations in relation to, in other cases, about the approach that French law takes.
Yeah.
That evidence is primarily directed to issues of whether or not there's a stipulation d'autrui and the
how it's open for acceptance by third parties,
exactly.
It becomes immediately binding.
Exactly. What I don't think there is evidence relating specifically to what might be called the substantive or formal content. The substantive content of the FRAND obligation.
Which is rather what I thought, which is why I was asking my question.
Yeah.
Since we don't have that, I'm just asking for your submission. How do we approach this point on the interpretation of the undertaking, which you're now advancing? And my question simply was, we don't have evidence of foreign law on that. Is your position that we simply would apply English principles of construction?
Yes, I think the starting point would be that one would apply English principles of construction insofar as the FRAND. Yes, the only reason I hesitate is because this is a jurisdictional application, and the question is whether there's a serious issue to be tried. It might be said that if one adopts the procedural course in relation to this that's recommended to addressing this issue, on the assumption that you find that there is jurisdiction, there would then be a hearing to determine essentially the content of the application. All I have to show at this stage is that there is a serious issue. I don't need to satisfy your lordships, at least my submission, I don't need to satisfy my lords.
Yeah.
My interpretation is unquestionably correct.
No, but if we're to address whether there is a serious issue on the question of interpretation, we need to know what principles we're applying.
Yes.
I may be wrong, but I have in the back of my mind somewhere in the papers, it may be one of the judgments below, there is at least a sort of one-sentence summary of the general French law rules about contractual construction, which didn't sound miles away from us.
Yes, there is, and I'll get the reference.
Yeah, I mean, don't do it now if you don't want, but my concern is the idea that we've just got to default back to English ones. I think there's something in the bundle about the general French principles of contractual construction.
Yes, that is right, and I'll
Okay, right. Let's not take up more time on it now, but I mean, certainly I would be interested just to know what your submission is as to how we approach what's on your first submission. It is a very important point, how one interprets the obligation in the ETSI policy.
So just in terms of the structure of the argument, if we are wrong in relation to the stronger form of the obligation, namely that all licenses that under the SEPs are subject to the FRAND obligation, even if another license is also offered, which is the first aspect. Even if we're wrong on that, there is a second aspect, which is the 27.2 point, which I think it's probably fair to say attracted Lord Justice Arnold more, and he deals with it in greater detail in his paragraph 95, namely, in the circumstances of this case, that this is the FRAND obligation.
So you have, as I understand it, in your case, there are 70 plus licensors with hundreds, if not thousands, of SEPs, and it's just impracticable for individual implementers to go around seeking a bilateral license for each of them.
Indeed.
Sure it is.
And that becomes more and more the case. The more licensors join the pool. Because the relative cost, which is one of the considerations that affected this court and the lower courts in Unwired Planet, was the relative cost of going for a global license and national licenses. Obviously, it was possible in some sense to go for national licenses formally, but what attracted the court was, well, actually now we've got a global bundle. That's the FRAND bundle. And all we're saying is that it is arguable that the court might in due course accept that was the appropriate way as matters stand.
Has anyone done a calculation of what Interdigital's take is from the currently charged 5G platform license rate? It would just give one a handle on any disproportionality between what you're arguing about and how much effort you've got to put in to get a bilateral license from an owner like Interdigital.
Well, that depends on what one needs to do. So there is certainly evidence that resolving these FRAND cases on a bilateral basis is very expensive, and there's specific evidence relating to the costs of these cases, at least in the United Kingdom.
I just want to see what you're fighting about.
There is also evidence, some of which is confidential, relating to the share that Interdigital would take. And it's not necessarily possible for my lords to know exactly what the number is, because if one thinks about this on a unit basis over the term of the agreement is itself confidential, but I think it's not confidential to say that it is a long-term agreement. What the take would be depends on how many vehicles are sold that are enabled.
Oh, I meant per vehicle.
Per vehicle?
Yeah.
Yes, there is that, and it is in the confidential materials, tab 34.
I'm sorry.
We'll need the page number.
I'm sorry. Yes. It's 529.
Thank you. And that will be in the confidential bundle, obviously.
That's in the confidential bundle. And very briefly, one of the, my lords have picked up on it already, undertakings take from the platform license depends on evaluations of what their share is of the SEPs to which they've contributed, and there's a complex mechanism for determining that. But I don't think my lords need to go into that now. As my lords appreciate, this issue is, in some sense, independent of the precise sums, because if one considers the transaction costs of 85 licenses, assuming, for example, that some of them dig in, if I may put it like that, and say, well, actually, we're not prepared to offer you the license is clearly not FRAND, then the transaction costs of getting a FRAND license are high. And my lords, one of the points that you will have picked up on is that there is, in some sense, systematic overcharging here. That was one of the points made in the United Kingdom IPO consultation, is that there is evidence that SEP owners have sought to obtain many multiples often of what terms are in fact FRAND in their negotiations. So the costs of actually getting a whole set of FRAND licenses is potentially very high. And my lords may be aware of the litigation that's taken place in relation to FRAND licenses on the evaluations in this jurisdiction. In none of them have the courts awarded the level that the SEP owner was actually seeking. And it's fair to say that nor have they always agreed with the implementer.
Surprise, surprise.
Surprise, surprise. Right. But if one thinks about particularly smaller undertakings, they may simply not be in a position to address this. And there was discussion in some of the cases, including in particular IDC and Lenovo, of the position of smaller undertakings who were then essentially obliged to sign up to very large sums.
And did you say there was some evidence in the bundle about this background?
There's evidence in, well, the points are made in the submissions of the ACT in their references to the IPO consultation. That's at 195 of the bundle, where the cross-reference is to paragraph 36 of the consultation. So the lack of pricing transparency means that licensees can overpay. We've seen evidence emerging through litigation that licensing offers made by SEP holders have exceeded court-adjudicated rates by 400 to 500 times. Further, not all licensees, and especially SMEs, can currently afford to challenge this.
Yes, thank you. In fact, you referred us to that already.
I think I've referred, my lords, to that, and that is, in our respectful submission, a sound underpinning for the second aspect of our argument. So can I briefly run through the points that we make in relation to this argument, which we, if I can take it up at page 37 of our written case. The first point is that there is no basis for interpreting the ETSI obligation as one which means that someone seeking to license their rights together means that the obligation doesn't apply, even if there is an alternative means of obtaining rights individually. Secondly, in paragraph 33, and I think that the point I've already made it, is that if one's interpreting the ETSI obligation in accordance with its purpose, and those purposes were articulated in Unwired Planet, they should be interpreted so as to avoid risk of hold-up. And the risk of hold-up is the risk of having terms that are not FRAND. And if one has a market in which essentially the alternative is impractical at licensing, there is a real risk that terms would not be FRAND if they were not subject to any regulation. The third point it arises, and I think I've made this point already in relation to the competition point, but the way in which we put it in our written case is that the approach of the majority would risk jeopardising the safe harbour protection enjoyed by SEP patent pools. One might say, additionally, the fact that pools were only regarded as entitled to the exception if they were themselves offering FRAND terms is a strong reason not to exclude that obligation from those licenses, even if other licenses may be available. Fourthly, it has been held that it is arguable that an implementer must accept an offer of a license under a patent pool, and that was a point made in the Mitsubishi case. And in our respectful submission, that's not unsurprising, because patent owners say, and my Lord has seen the other material in relation to this, the reason that you need to take a platform license is because that platform license is FRAND.
Yeah, but that's just a reflection of the operation of the ETSI scheme. That if you are being offered a license on FRAND terms and you say no, well then you're completely exposed to due enforcement of the patent.
Exactly. Fifth, it's said against us that SEP owners have only relied informally on the availability of licenses. That's simply not right. And that, in our respectful submission, supports both the point that formally the obligation may exist, but also that it is desirable that there should be evaluation of whether or not the platform licenses is the FRAND license in this case.
Is that back to evidence about the 4G license? Or is there some evidence, even in relation to the 5G pool license, that some owners are saying you can find it in the 5G pool?
I don't think any owners have yet said that you can find it in the 5G pool, but our point is a more general one in relation to pool licenses of this kind. Why would they not seek to do so?
And just on the timing, I thought one of the reasons that Tesla was taking these proceedings was to try to sort this out well in advance, right, before one gets into these sorts of problems.
Sixth, the fact that the master agreements don't say that Avanci is agreeing to fulfil the FRAND commitments. That's neither here nor there. The FRAND commitments exist independent of the master agreement between the SEP owners and Avanci. The point of the claim is to ensure that, pursuant to the relevant agreement, Avanci arranges terms that are only FRAND. Seventh, the fact that Avanci doesn't itself owe an obligation is no bar to declaratory relief. And I think I've made that point. I'll come back to it briefly in connection with the declarations point. The further points really arise more under the head of declaration than they do under the head of whether there's a serious issue. So I'll address them under that head if I may. But we respectfully submit that all of those points are sufficient to raise at least a serious issue as to whether or not the platform license must be FRAND. And in relation to the second aspect of the case, again, I think I've developed it sufficiently, but it's further developed in writing in paragraphs 42 onwards on pages 40 to 41 of the electronic bundle. The central point being that if, as in Unwired Planet, the commercial reality is that the Avanci license is in some sense, the logical license, and the alternative, which is a series of other licenses with 85 others, is an impractical alternative, then the Avanci license must be on FRAND terms, because otherwise, essentially what the SEP owners would be saying is you can't have FRAND licenses. The only license that is on offer is a license that we cannot warrant is FRAND, and insofar as you need other licenses, you will need to go and get them from 85, which will consume resources and create massive risks to your business by this alternative route. So the issue of the practical deliverability of alternatives is a key point, and a point which we respectfully submit Lord Justice Arnold was right to recognise in holding that this was arguable in his paragraphs 94 and 95 of his judgment. And in our respectful submission, it is not an answer to those points to say, well, simply because there are alternatives available, and in particular a bilateral license, that this platform license is not the FRAND license. That is a matter to be determined in due course, but effectively what the majority of the Court of Appeal is saying is, well, the formal availability, if I may put it like that, of bilateral licenses, regardless of how practical that is as an alternative in any given circumstances, is enough to discharge the ETSI obligation. And we respectfully submit that that is not the approach taken by this court in Unwired Planet, and it's not an approach that should commend itself. Part of the reason that it shouldn't commend itself is that it is an approach calculated, in both senses of the word, to lead to hold-up and the delivery of benefits that are the fruit of hold-up. Because if it's said, well, the platform license doesn't have to be FRAND, and there are no real practical alternatives round the back, that is essentially saying, well, for practical purposes, you don't have a choice. And
you say that's confining commercial practicality strictly to the determination of what is or isn't FRAND.
Correct.
Rather than to the construction of the ETSI undertaking.
Indeed. And I don't say that commercial reality is to be applied to the construction of the ETSI undertaking, save to this extent, that if one is considering what the ETSI undertaking by reference to its purpose, then if one can see that its purpose, which is to avoid holdout, is not being fulfilled by a particular approach to the undertaking, that is relevant to how it should be approached. And there is no debate that the ETSI undertaking is there. I mean, its key rationale is to avoid holdout. So that is really all I wanted to say for present purposes on serious issue to be tried.
Your two arguments, two different ways of putting it. You say you win on either.
Yes.
Are you? I mean, they're both arguments why you say that the majority was incorrect. Is it possible to construe what Lord Justice Darnell was saying as covering both, or are you only putting that forward as his that his is only the second of those?
Yes, I understand where my Lord is coming from. We respectfully submit that it does cover both. If you look at paragraph 94 and 95 of his judgment, so it's bundle at 261.
251?
I'm sorry, 261.
261, sorry.
261.
I misheard you.
Although I would accept it's not absolutely clear, in paragraph 95, first sentence, he records Tesla's argument that amounts to saying the royalty rate charged by Avanci does have to be FRAND. Tesla accepts that Avanci does not itself owe any FRAND obligation, but turns out it's not determinative, and Tesla alleges as a matter of commercial reality the only license of the UK SEPS is covered by the Avanci platform. So that focuses really on the second aspect of the argument. But if you look at paragraph 94, so far as the first question is concerned, it's necessary to be clear as to the effect of the rival contentions. Avanti's argument about saying the royalty rate of £32 does not have to be FRAND, and it's implicit in the argument the royalty rate can only be challenged if at all through the mechanism of competition law. And we respectfully submit that this formulation of the respective arguments is sufficiently broad, at least, to cover both contentions. Although I accept that it's focused more on the argument we put in 27.2 than at 27.1.
Thank you.
So the next question is there any express exclusion? And if I can just deal with this very briskly, because really it's a matter for my learned friends to show that just before I come on to the
Is this the travaux préparatoire?
This is the travaux préparatoire point. And we can do this from the electronic bundle starting at page 704, which is an extract. 704, which is an extract from a previous version of the draft.
Can I just clear one thing away? You're not taking any objection to the admissibility of the travaux? I mean, we're launching straight into them.
We just don't see that this point goes anywhere at all, and I'll just explain it very briefly, and then perhaps I can reply on it if it's necessary. But can I just explain why?
I have no idea whether French law takes anything remotely approaching our...
No, it's not even a French law point as such.
No.
What it is a point where they say there was among other clauses in an early draft of the IP policy, a clause relating to joint ventures, acquisitions and divestiture of affiliates, which you find at 704. And our point is simply a negative one, which is this clause on its face has absolutely nothing to do with patent pools or platforms or anything along those lines. What it is concerned with is other entities which might have patents where there's an attempt to ensure that those are subject also to the ETSI undertaking. But the point is even worse than that, because what happened later, and it's referred to in my learned friend Skeleton, is that there was a considerable objection to the draft ETSI policy, and you can see that in letters from ETSI members in 740 onwards. Not a single one of them mentions clause 15 at all. And when this matter came to be discussed in the ETSI meetings, where one sees the minutes from page 756 onwards, what appears is that there were two contentious issues. One of them was a so-called 180 days issue, which relates to a completely different part of the debate, and the other was arbitration, whether there should be compulsory arbitration, essentially, with respect to these issues. There were then two other issues that arose in relation to this, where there was a debate about that. None of those had anything to do with Clause 15 at all. And ultimately what happened with this ETSI policy was that it was substantially redrafted and Clause 15 fell out. But since Clause 15 fell out wasn't dealing with platforms at all, and there was no discussion of this, the idea that there was an express intention to exclude platforms from the ETSI undertaking is simply untenable. It has never been suggested in the entirety of these proceedings before, until a few weeks ago, that was even a possibility. And it is of some significance that is not the case, because that didn't happen, because it would, if correct, have been a complete answer in some sense to my learned friends, to my case, if there'd been a express repudiation of the idea that the undertaking should apply to platform licenses. So we respectfully submit, subject to anything that my learned friends may say, try can answer, that this has got that this takes matters no further. So can I then turn briefly to the declaratory?
Just before you do, is a fair summary of your position that the ETSI undertaking properly construed is simply agnostic as to whether a FRAND offer of a license is in a bilateral or multilateral document?
Yes.
Yeah.
Or how it's made. The ETSI undertaking doesn't say even that you have to license all of an undertaking's patents together. So it's not prescriptive in that sense. What then needs to be fleshed out in its application is how that policy applies in any given circumstance, and that's the core of our case.
Just before you leave this, have you pleaded your case on this anywhere? On this, that platform licenses must be FRAND?
I'll certainly...
At some point, could you come back to that and just just point us to it so we can actually see the formulation of your case. I'd certainly, for my part, be grateful.
Yes. Perhaps I could return to that if that's convenient. So can I deal quite briskly with the law on declarations? Because the fundamental propositions in our respectful submission, subject to the points made by my Lord Briggs, are not really in doubt. On this section, we really have 4 points. First, on the general power. Secondly, whether declarations may be made with respect to rights not vested in the parties to the proceedings. Third, there's a brisk point on vestel, which has arisen. And fourth, the position of third parties affected by the declarations, what I think of as the Tyne and Weir.
Lord Legate's judgment, was it?
Leggett and Lady Simler.
It was Lord Leggett and Lady Simler.
Thank you.
I'll come on to that.
Yeah.
So, general power. In our respectful submission, the scope of the general power was well summarised by Lord Justice Arnold in the passage starting at paragraph 47 of his judgment. It's at page 248.
Thank you.
And we don't need to go through the whole history, but he obviously cites the key sources, Messier Doughty, FSA and Rourke, and Feetham and Levy on the issue of whether or not a declaratory relief should be refused on the grounds that claimants are seeking declaratory relief as to the effect of a contract to which they are not parties. We don't have that, I think, in the bundles, but in our submission, all of these are sufficiently established propositions. He then goes on in paragraph 72 on page 254 of the electronic bundle to refer to the Milebush Properties case and the approach of the Court of Appeal there, where Lord Justice Mummery and Lord Justice Jackson, referred to at paragraph 75, say the authorities show discretion to grant a declaration now covers a wide range of cases. The authorities show how it may be granted in private law proceedings about the disputed construction of a document affecting a claimant, even though the claimant was not a party to it. And he refers to the dissent there of Lord Justice Moore-Bick, where what was said was that there might be an even wider power. He then refers to vestel, and perhaps I can deal with that very briefly, because it's said that our case is contrary to vestel on the basis that we're seeking a freestanding FRAND declaration. In our respectful submission, we're not doing that at all. The relevant passage from vestel was cited by Lord Justice Arnold at page 257 of the electronic bundle. It's paragraph 52. And the issue in vestel there was whether or not there was an undertaking, so whether there was a legal standard by reference to which a declaration could be made, not some generalized point in relation to FRAND or FRANdness or non-FRANdness. And the reason that the Court of Appeal said that was not acceptable was because there wasn't a standard. Here, we say there is a clear ETSI undertaking. That was not the case in vestel. And so, to the extent that that is required, this case is the right side of vestel, not the wrong side. So, our submission is that the jurisdiction is sufficiently broad to encompass making a declaration as to the FRAND, as to what are FRAND terms, to determine and declare whether the terms that are offered do satisfy the ETSI obligation, and if not, what terms, if offered in this way, would satisfy.
Well, that's stating the outcome, but what's the principle, what's the activating principle that leads the court to go one way or the other way in the exercise of its discretion?
So the activating principle is that of whether there is a useful and legitimate purpose.
Right.
I'm sorry, my Lord, I was just dealing with the point of as it were, scope. Obviously, I have to satisfy my Lords that there would be a useful and legitimate purpose. And we accept that the purpose of a declaration must be legitimate, albeit that we don't say that in this case it really matters whether the issue is not legitimacy or illegitimacy. The issue here is utility of purpose, before one gets to the question of whether there can be a fair determination. And in our respectful submission, there is a clear utility of purpose. And that...
I mean, isn't it the same utility of purposes as in Unwired Planet?
Yes.
That if you're an implementer, you need to know what price you pay so that you can't be subject to the very powerful remedy of injunctive proceedings to enforce a patent.
That's the beginning and end of it.
You say you have a legal right to a license on FRAND terms.
Correct. And we have a correlate, if I may put it like this. Procedural entitlement is put it too strongly because it's still a matter of discretion. a correlate legal claim to determination of what those terms are that must be offered if you accept my first argument that it is arguable that they must be FRAND.
Through the platform. Through the platform.
Indeed, through the platform, yes, of course, yes. Through the platform.
Yeah.
I mean, obviously, if you don't accept the first argument, then all of this falls away, but if you accept the first argument, then, in some sense, it's not that the utility proves itself, but it nearly does, because...
well, in the sense, the utility drives you to go further and actually come up with a figure, because otherwise people don't know what they've got to pay to free themselves from that threat.
Correct. But the utility it goes beyond that, because there's also utility in some sense in the platform knowing what it needs to do in order to be FRAND. Now you might say, well, that's not, why should we care about that? But the reason is important, because if you're trying to make licensing through the platform the dominant way of licensing in this area, or it has become the dominant way, then there is clear utility in the whole market knowing whether or not that platform is licensing on FRAND terms.
It's no part of our business to try to make it the dominant way, but your second point, that it already is, seems, to my mind at least, rather more worthy of consideration.
Yes, but
it's not our job to direct the industry what the best way forward is. But you simply say, looking at the 4G and 5G experience, there isn't really any doubt about it.
Yes, that's the point. On utility, though, my point is that it's not just useful for one side of the market, if I may put it like this.
No,
We're dealing with a double-sided platform.
Yeah.
There's a utility on both sides of the market to know what the FRAND terms are, because...
I mean, I can see that, although seeking it for myself, I'd have thought that utility tied to what you described, the correlate of the legal claim, telling people what they must pay if they're to avoid infringement proceedings, seems clearer or more direct.
My Lord is right, and that's why I put that as the first. That's the structure of this case is what needs to be paid in order to avoid infringement, if I can put it like that. And the correlate of that is what terms need to be offered properly in order that the implementers can pay those terms properly to avoid infringement.
But in the case of an Avanci platform figure, which is one figure as I understand it, one has to determine the overall FRAND rate for the whole platform for you to know what the FRAND rate is for you.
Yeah, absolutely.
And that is something you say you're entitled to.
That's a more elegant way of putting my point. But the issue that I said I'd come back to, and it still merits your attention because it is a segue in some ways to the next point in relation to the procedural aspects of making a declaration here, and whether procedurally, even assuming that you're with me this far, there is unfairness in making a determination without, at this stage, having joined every other member of the SEP platform, which is the point that's put against me. And I'll explain why that's not necessary in this case, notwithstanding the very strong and entirely justified guidance from this court as to the importance of ensuring that interests are represented where there is where declaratory relief is made. But can I, before we get to that point, just show you one document in relation to the way, at least, in which the 4G terms were determined, just to satisfy you, or at least show you prima facie, why this notion that you need everyone in, and Avanci won't do, and Avanci plus Interdigital won't do, is not justifiable. It's at 576 of the main hearing bundle, so that's Appendix 1, tab 38. And this is an email from Avanci to a representative of Tesla. And what it does, among other things, is in relation to the 4G platform, seek to explain why our royalty rates are FRAND. And I don't invite you to read this in detail now, but the bottom line on this is what they have sought to do is to take percentages from various cases of a notional royalty stack and then apply those in what's been called a top-down approach to the Avanci pool by way of analogy with pricing of cellular phones. And this is the approach that they've taken. It's obviously not something that we had any involvement in. It's not something I think Interdigital had any involvement in either. And I don't think there is any evidence as to how they came up with the very significantly increased price for the 5G platform. But there is bound to be material which is of this general kind in relation to how pricing was established. And we simply say, if it is possible fairly to determine whether the approach that they have taken to pricing is a correct approach, and in particular a FRAND approach, then that should be done. And the question procedurally of what needs to be done in order to ensure that relevant interests are represented is in some sense a separate question.
I mean, it's almost an evidential point. I mean, if you're following your correlative right argument, if it is the right of Tesla to pay, let's say, $25 a car, and Tesla presents evidence to support that figure, well, the $32 figure will be supported by whoever wishes to justify that. And in a straightforward fight between Tesla and Interdigital, it would be Interdigital that had to prove that, and there's little doubt they'd look to Avanci. And indeed, I think Avanci have said that if the case proceeds against Interdigital, Avanci would want to come in to justify it.
Well, this is exactly the point. that if the claim proceeds against Interdigital, who is, as it were, potentially the undertaking that
yes, then it's just an issue, Interdigital saying, well, potentially on this theory of going forward, well, the FRAND offer is the platform. That's how we satisfy our ETSI obligation, at least on one version of the argument. Is that FRAND or not? And then it's a matter of evidence on both sides, talking here about Tesla and Interdigital as to whether they make out that case or you make out your case.
That's absolutely right. But in some sense, the litigant in the lead on this, on the other side, would almost certainly be Avanci. And Avanci, yes, in some sense, is certainly in on any view if you accept the jurisdictional arguments, because they're either in as a defendant in their own right, or yes, they have said that they will be in, yes, if there's jurisdiction against Interdigital. So Avanci is the undertaking that sets the terms, knows the basis.
Yeah, but I was just trying to bring out that the nature of the claim you're seeking to bring, relying directly on the ETSI undertaking, is a claim against Interdigital,
yes,
who have given the undertaking. Avanci has not. But I think what you're saying is, for that case, between Tesla and Interdigital to proceed, debating what are the FRAND terms in relation to the platform, if that's what you have to look at for the FRAND terms, without Avanci is like Hamlet without the prince.
Correct.
And of course they're going to come in, and indeed they've said, well, we jolly well want to be there if you're going to debate that, because we want to defend it.
Correct. And Interdigital say, well, this is not our fight. I mean, that's said on more than one occasion. Well, it is their fight.
Well, it's their fight if they lose on the first issue as to what their
correct
obligation is.
Oh, indeed. My Lord, all of this is premised on there being a serious issue.
Yeah.
If there isn't, then
yeah,
none of this matters.
Absolutely. But if there is, then I think what you're saying is, well, then it is their fight, because that's the nature of the proceedings.
That's my point. But the fact that it is their fight doesn't mean automatically that they, or indeed any other licensor or licensee, has to, as it were, descend into the ring. Because if it's right that Avanci would seek to defend the pool, their terms, they are in some sense the best undertaking, in some respects the only undertaking, given the fact that they were the ones who devised the terms in the first place.
Yeah, I mean,
to defend them.
I appreciate this theoretically. Theoretically, Interdigital could defend the FRAND rate, and Avanci could say, we'll give you lots of help, we'll give you all our material. But, I mean, no one actually thinks that that's what would happen, and Avanci doesn't say that's what would happen if you get to this stage of the argument.
Exactly. But it goes beyond that. And I just want to, before we come to Tyne and Ware, just mention one other thing about the procedural fairness aspect, which is that the evidence in this case of Ms. Brodie, which is at 593 of the electronic bundle.
And sorry, remind us, Ms. Brodie is...
Ms. Brodie is a solicitor to Interdigital. It's at paragraph 39, and she says, if a declaration as to license terms is made against Avanci, Tesla has not identified a realistic situation where Interdigital would choose to remain in the Avanci 5G platform, but would not approve any variation to the license terms proposed by Avanci to reflect the court's judgment. Ms. Hopewell accepts that were a court to settle the terms of the Avanci 5G platform license, that it would be very surprising if the 5G platform members did not consent to Avanci offering Tesla a license on the court-determined terms, and as she notes, she agrees with that. So what we have is a situation where one can be confident on the evidence as it stands, that essentially the members of the pool, licensors of the pool, would fall in behind the court's judgment, and they'd say, all right, well, if you decide that the right rate ought to be $24, then that's what we'll do.
Mr. Alexander, that's put it as a point against you, because they say, well, in those circumstances, they ought to be joined.
Indeed, and we don't have a difficulty. Oh, you mean everyone else ought to be joined?
Yes, well, it affects their rights.
No, I understand that, but then the question really is whether in circumstances where you're doing a license on the basis of a of a bundle and where the issue is the pricing of the bundle as a bundle, every member of the pool has to join or be joined in order for there to be a fair determination. And our respectful submission is that that is taking the approach in Tyne and Weir, which I'll come to briefly, too far. In that case, while it was recognised...
you don't, just before you go on, you don't dispute that every member who wanted to come in principle, ought to be at liberty to come in, either individually or through a representative.
Of course. Yeah. We don't object to anyone coming in who wants to. Realistically, however, it is unlikely, I think, we would accept that everyone would want to be joined as a defendant, or I don't think there's a procedure for joining interveners as there is in judicial review proceedings or public procurement proceedings under the CPR. But the reality is that anyone who wished to contribute to the debate would be able to contribute to the debate if they wanted to. Indeed, it is, we would submit, inconceivable that if this claim went ahead, the debate wouldn't be notified to the members, they may be asked for their views, potentially they may have evidence to give. We think it's unlikely, given the way that the pool licence was developed, at least under the 4G licence. But we are not seeking to shut out representatives if they wish to attend. What we are seeking to say is that this court, at this stage of the proceedings, should not say that the proceedings should come to an end because there is a possibility that others may wish to come in, even though that hasn't materialised. And this is the point in relation to Tyne and Weir. In that case, as my lords will know, that's in Authorities, tab 148, it's electronic bundle 2428.
This was a point that particularly troubled the judge, I think. Is that right?
It did. Well, it troubled both the judge and the majority of the Court of Appeal, it's fair to say.
Sorry, page.
2428.
2428.
240, well, the passage is at 2428. The case starts at 2404, and it's the most recent case in which my lords have made observations in relation to, well, perhaps not the most recent because there was Dartmoor as well, but a recent case in which you've made observations in relation to the role of the public. And we don't obviously seek to criticise any of that. But one does need to consider this in the context in which these observations were made. Essentially, the passage that's relevant is starts at paragraph 55. That's 2427, and effectively, what was criticised was the approach of seeking rectification of a collective bargaining contract, a collective agreement that was said not to be enforceable, which then, because it was incorporated into contracts of employment with individual employees, would have a material impact on their pay and conditions. And
yeah, I mean, it's a bit more than that. It would become a term
yes,
of their
absolutely.
individual contracts.
It would become a term of their contracts. And this was a matter that rightly exercised this court. But if what in our respectful submission this judgment does not suggest is that every single employee whose contract was potentially affected needed to be joined into the proceedings in order to make a fair determination. Indeed, in paragraph 57, there was a debate about Nexus, which was the undertaking seeking to effect the changes. appeal to practical considerations, argues that it's the unions who conducted the negotiations, they can give relevant evidence, and it was said that the proceedings against the individual employees would have undesirable practical consequences. They might have to sue every affected member of its workforce, which would be damaging to industrial relations. But they acknowledged that it could, in principle, be avoided by bringing an action against representative defendants, but it suggests that using the procedure could conceivably give rise to problems, and a claim brought against the unions is a simpler and more satisfactory way of determining the issue. And the court was not impressed by those arguments. But what was said was that, in paragraph 58, is that in practice the unions were likely to have the conduct of the employees' defence, and as to the allegedly undesirable practical consequences, it's fanciful to suggest that Nexus might have to join every affected member of its workforce as a defendant. So the court, even in that case where it was recognising the importance of doing justice to a claim that was seeking to amend important contracts of employment, it was not suggested that it was necessary to join all of the workforce. And what was concluded in that paragraph was, as we discussed below, the issue of rectification could also have been decided if Nexus had raised it. There's no reason why this issue could not be resolved in future action between Nexus and a single employee or group of employees. So, in our respectful submission, even where there is recognition of the importance of other interests, it can be the appropriate approach to have a matter determined by an action between one undertaking, which is not representative in the legal sense representative, but an appropriate undertaking. If there is another undertaking, then in that case the union, in this case Avanci, which is able to conduct the defence of the proceedings in a sensible way. And we respectfully submit that what the Court of Appeal should have done in this case is to say this issue, in terms of fairness of procedure, is a procedural one, that it doesn't affect the serious issue to be tried, or the prospect of a declaration being made, but should be reviewed, whether in directions or in future conduct of the proceedings, to determine realistically what other interests need to be taken into account in determining whether or not this licence was FRAND in fairness to all concerned.
The last sentence of paragraph 58 seems to me to be potentially of significance as well, because that's saying that if Nexus had brought proceedings against a single employee to determine an issue between Nexus and the employer, what are the terms of your employment contract, the court would have addressed that.
That was my point.
Sorry, I may have been too slow.
I'm sorry, I didn't make it clearly enough, but that was exactly my point.
So here again, as I'm understanding the point that you're making, you're saying, well, since the utility of the declaration is directed to Tesla knowing precisely what sum it would need to pay by way of a platform-based license, if that is the relevant FRAND license, which is going to satisfy the FRAND obligation. Well, that is already an issue joined between Tesla and Interdigital, and they need to know the outcome to that. It's true that others may be affected, and one will be concerned to ensure that they have a fair opportunity to contribute. But I think you're saying it would be a very strong thing, given that if that is the nature of the issue between Tesla and Interdigital, that you can't get a conclusion on that, which is the whole point of the
My Lord, that's exactly my submission. And so for those reasons, we submit that the Court of Appeal's approach to this was, if I may respectfully say so, or the majority of the Court of Appeals was too narrow, both in respect of the serious issue aspect and in respect of what was required in order to have a fair determination of this issue, and that the claim in principle, subject to jurisdictional matters, ought to have been allowed to proceed on that basis. I noticed the time. There's one very short point to cover on ground 3, but otherwise, unless my lords have questions, questions, that concludes.
Well, we'll break there and resume at 2 o'clock.